Alabama's congressional map has just been thrown into, absolute chaos.
Yeah.
And we are only weeks before an election here.
Yeah, it is a complete mess right now.
It really is. What we're watching is this high-stakes game of political ping-pong between a federal district court and the U.S. Supreme Court. And the rhetoric is just explosive. We're talking accusations of Jim Crow tactics, 11th-hour special sessions, and a desperate legal fight over whether a map was drawn to protect a political party or to intentionally discriminate based on race.
Right, with control of the House of Representatives potentially on the line.
Exactly. But really quickly, before we rip into this timeline, a quick housekeeping note. To keep getting these deep dives, take a second to like, subscribe, follow, and turn on the notification bell right now. We really appreciate it.
We definitely do.
And also, delivering a strict 15-second legal update on the Martin Stevens versus OpenAI matter. To be clear, it is still not a lawsuit. We are in a voluntary quiet period at Stevens' request. And while we hope for a settlement, we have no knowledge of any progress and are not implying that any discussions are underway. Also, the dead man switch has not been activated, meaning Stevens is physically and legally safe.
Okay, good to get that out of the way.
Yeah, absolutely. So moving completely into our main mission for today's dive into these Alabama redistricting sources. For you listening, we're going to untangle the timeline of this legal showdown, explore this incredibly complex battle between partisan gerrymandering and racial gerrymandering, and look at how this is impacting the 2026 midterms.
So to really understand this, we have to look back at the 2024 elections. That's our baseline.
Right.
For 2024, Alabama used a court-ordered map, which was known as the Special Master Plan. It was drawn by an independent expert because the Republican-led legislature's 2023 map had been struck down.
And it was struck down because that 2023 map only had one majority black district out of 7, right?
Exactly. Even though black residents make up about 27% of Alabama's voting age population.
Right, so the court said, hey, you're illegally diluting minority voting power.
Yeah. So the Special Master Map steps in, and it creates 2 districts where black voters actually had a realistic opportunity to elect candidates of their choice.
Which totally worked out. In 2024, Shamari figures, a black Democrat, actually won District 2.
He did. So that map was functioning as the status quo. The political landscape had theoretically, adjusted to it. But then the legal ground shifted completely in April of 2026 with a landmark U.S. Supreme Court decision.
Right, Louisiana v. Calais.
Yes, Louisiana v. Calais.
Reading through the sources, this ruling is the catalyst for the current chaos. It basically narrowed how map makers and courts can use race in redistricting.
It fundamentally altered the standard of strict scrutiny. Before, courts looked at whether race was a predominant factor. But Calais raised the evidentiary bar, making it incredibly difficult to use racial demographic targets as the primary driving force without violating the Equal Protection Clause.
Wow. Okay, so it basically signals that maps drawn explicitly for proportional racial representation are constitutionally suspect now.
Exactly. And Alabama Attorney General Steve Marshall sees this ruling, and he immediately goes to the Supreme Court.
Right. He's like, aha, new rules.
Basically, yeah. His argument is, well, under your new standard, the court-ordered special master map is an unconstitutional racial gerrymander, and our original 2023 map is actually perfectly legal.
And the wild part is, on May 11th, 2026, the Supreme Court actually agrees with him. They hand him a victory, vacate the lower court's block on the 2023 map, and tell them to reconsider the whole case using this new Calais framework.
Which caused an immediate political reaction in Alabama. Governor Kay Ivey called a special legislative session right away.
Right, and scheduled a special primary for August 11 to use that resurrected 2023 map.
Yeah, she was maneuvering to lock it in for the upcoming elections.
When I was reading this, I kept thinking of this analogy. It's like you're playing a board game for 2 hours, right? And right before the final turn, the referee suddenly points to a brand new rule book and says, wait, hold on, we have to recalculate the whole board.
That is actually a perfect analogy because it highlights just how disruptive this was. But, Justice Sonia Sotomayor's dissent in that Supreme Court decision is crucial here.
She was joined by Kagan and Jackson, right?
Yeah, she pointed out a huge legal distinction. The Calais ruling dealt with the Voting Rights Act and the dilution of votes based on racial demographics. But when the lower court blocked Alabama's 2023 map, they didn't just cite the Voting Rights Act.
Oh, right. They cited the 14th Amendment.
Exactly. They found that Alabama violated the 14th Amendment by intentionally discriminating against black voters.
Intentionally. That's a huge word there.
Huge. Sotomayor's argument was that a finding of intentional discrimination operates completely independently of the Calais ruling. So even if you tighten the rules on how you can use race under the Voting Rights Act, the 14th Amendment still completely bans intentionally drawing lines to disenfranchise minority voters.
Which basically gives the lower court a roadmap for what happens next. Because on May 26, the three-judge lower court panel judges, Marcus, Manasco, and Moorer, they look at the map again under the new standard, and they block it a second time.
They delivered this massive 268-page order, and they were surgical about it. They stated they could not allow Alabamians to vote under a plan tainted by intentional race-based discrimination.
Tainted by intentional race-based discrimination.
Yeah, they basically used Sotomayor's logic. Calais or no Calais, the 14th Amendment violation is still there.
I found the details of how they proved that intent so fascinating. They use this thing called the Arlington Heights framework.
Yeah.
For you listening who might not be an appellate lawyer, how does that actually work?
So, Arlington Heights is a precedent from a 1977 Supreme Court case. It's meant for situations where a law is outwardly neutral, like they didn't literally write, "We are doing this to disadvantage black voters" into the bill.
Right, no one writes that down.
Obviously not. So the court needs a way to figure out the true motivation. The framework acts like a forensic checklist. Judges look at the historical background, the specific sequence of events, any sudden departures from normal procedures, and the foreseeable impact of the action.
Okay, so it's like forensic accounting for legislative behavior.
Yeah.
And the departures from normal procedure in Alabama were glaring. Like, they conjured these non-negotiable rules out of thin air, literally in the dead of night.
Yeah, the most prominent one was the sudden demand that the Gulf Coast, Mobile, and Baldwin counties absolutely had to be kept together in a single district.
Why does keeping the Gulf Coast together matter so much?
Well, it's purely mathematical. Modern redistricting uses GIS software, right? So when map makers lock in a geographic constraint like that, the software has to ripple those population shifts throughout the rest of the state to keep the populations equal.
Oh, I see.
And expert testimony showed that by locking the Gulf Coast, it became mathematically impossible to create a second district where black voters had an opportunity to elect their preferred candidate.
Wow. So they didn't have to target minority voters explicitly. They just created a geographic rule that mathematically locked them out.
Exactly. And the sources also detailed how the map strategically cracked the Black Belt community.
Right, the cracking of the Black Belt. They specifically focused on the historic city of Selma in Dallas County.
Yeah, Selma is a major hub of the Black Belt, but the 2023 map deliberately moved Selma into District 7, which was already a heavily packed majority black district.
So they packed Selma's voters into District 7 to take them out of District 2?
Yes. By doing that, they effectively submerged the remaining black voters in District 2, leaving them unable to elect a candidate of their choice.
And the judges emphasized that this wasn't an accident. The mapmakers actually had demographic experts warning them that moving Dallas County would destroy District 2's viability for minority voters. But they did it anyway.
Exactly. So because the lower court used that Arlington Heights framework to dismantle the state's race-blind defense, Attorney General Marshall is now pivoting. He's appealing back to the Supreme Court.
But his argument is completely different now, right?
It is a fascinating legal pivot. The state is now arguing that the map wasn't drawn to discriminate based on race. It was drawn for partisan gain.
Partisan gain? Like, they're just admitting they were trying to rig it for Republicans.
Yes, they are explicitly saying they wanted to protect Republican incumbents and secure a 6-1 or 7-0 GOP delegation.
Because, under Supreme Court precedent, partisan gerrymandering is considered a non-justiciable political question, right?
Exactly. Federal courts can't strike down maps just because they favor one political party.
Which is wild. So it's basically the ultimate legal shield. If you claim you were just being ruthlessly partisan, the federal courts can't touch you.
And they have serious backing on this. U.S. Solicitor General John Sauer actually filed a brief supporting Alabama.
Really? The Solicitor General?
Yeah, Sauer argues that pursuing partisan goals even after previous court warnings isn't racially discriminatory. He says Alabama was just trying to protect communities of interest, like the Gulf Coast, for political reasons, not racial ones.
But wait, this is where the whole thing falls apart for me based on the sources. If their defense now is, hey, we were just playing partisan politics, why did the district court say there was absolutely zero evidence of that at the actual trial?
You hit the nail on the head. That is the Achilles heel of their appeal.
Huh?
The judges noted in their ruling that during the 11-day trial, evidence for a partisan motive was completely absent.
So when the legislative leaders were testifying under oath, they didn't mention this partisan strategy.
Nope. In fact, they testified that overtures from national party leaders didn't affect their work. When asked why they made specific map choices, they often claim they didn't know. Crucially, not a single one testified that the motivation was to benefit the Republican Party.
So they sit in a courtroom, under oath, and say partisanship wasn't the reason.
Yeah,
But now they're telling the Supreme Court it was purely partisan.
exactly. And the lower court judges saw right through it. They called the partisan defense a retroactive, lawyer-crafted excuse.
I think the phrase they used was a veneer of legislative regularity, right?
Yes, a veneer to cover up intentional racial discrimination.
That is just incredible. And look, we want to be very clear to you listening. We are impartially reporting the reactions from the sources here. We aren't endorsing either side. We're just looking at how explosive the fallout is on the ground.
Right, because the political reactions in Alabama are intense.
I mean, Democratic outrage over Governor Ivey's special session was just volcanic. State Representative Napoleon Bracey called it an all-out attack on the Black community.
And State Senator Merica Coleman had a 45-minute Facebook Live rant where she called the move, quote, bullshit, and asked how many more seats the Alabama Republicans want.
Yeah, and State Representative Wanda Lynn Jeevan went even further. She accused Republicans of turning the clock back to Jim Crow. She literally asked how long it will be before they reinstate poll taxes and literacy tests.
And to balance this out, we have to look at the Republican perspective, which A.G. Marshall articulated. They argue that in a conservative state, a conservative electorate should have conservative representation.
So they feel they're being punished for not creating racial quotas.
Exactly. Marshall argues that the court's forced racial gerrymandering is repugnant to the Constitution and that the state is just refusing to sort voters by race.
Okay, so you've got this huge ideological war happening in the courts. But why does this matter to you as a voter right now? Because running an election isn't just theory, it's a massive logistical machine.
A machine that is running out of time. We have to look at the testimony of Alabama Director of Elections Jeff Elrod.
Right, because the voter rolls unlock in a matter of days.
Yes. And Elrod testified that reassigning voters to the 2023 map at this late stage would take a, quote, Herculean warp speed effort. It would require all hands on deck, late nights, weekends, just to get it done.
Because if you mess that up, voters show up and they're in the wrong district or they get the wrong ballot. Which brings up the Purcell principle.
Right, the Purcell principle. This is a legal doctrine that basically says courts shouldn't change election rules at the last minute because it causes voter confusion.
But the irony here is just amazing. Usually a state uses the Purcell principle to tell a court, hey, keep our map in place, it's too late to change it.
Exactly. But here, the district court used Purcell to justify blocking the state's map.
Because enjoining the state's map actually prevents chaos.
Yes. The state's computer systems and candidate qualifying were already set up for the court's 2024 special master map. So switching back to the 2023 map now is what would actually cause the chaos that Purcell warns against.
It is just a logistical nightmare on top of a legal paradox. And synthesizing all of this, the core conflict is just wild.
It really is. The Supreme Court says partisan gerrymandering is legal, but racial gerrymandering is not.
But in a state like Alabama, voting is intensely polarized by race. I mean, the sources show white voters largely vote Republican and Black voters largely vote Democrat.
So when racial identity and political affiliation are that closely intertwined, disentangling them is almost mathematically impossible.
Right. Which leaves us with a final provocative thought for you to mull over. If political affiliation and racial identity are so deeply bound together in a state's voting patterns, is it structurally possible for a court to untangle them without essentially having to read the minds of the lawmakers who drew the maps?
It's a great question. Can we ever really separate the two?
I don't know, but they're going to keep fighting over it. Thank you so much for joining us for this deep dive. If you found this breakdown helpful, please remember to like, subscribe, follow, and hit the bell. Catch you next time.